welcome to our Constitution reading in honor of Constitution Month. To begin our reading, I'm actually going to acknowledge Natomas Pacific Pathways Prep High School. First, its choir is going to sing the national anthem for us. The national anthem, please come forward and kick us off. Pacific Pathways Prep High School choir. How inspiring, and that flag does indeed still wave. We are reading the Constitution today underneath that flag. The Constitution turned 236 years old on Sunday. The 14th Amendment turned 155 years old earlier this year. We are honoring the Constitution and the second founding today in this reading, this collective reading. The court welcomes students, teachers, lawyers, members of the federal bench, family, and friends. The Constitution belongs to all of us. It's for all of us to engage with it, to understand it, to take its words seriously. And by engaging in this public reading, we are doing exactly that. Thank you to the federal bar, to court staff, to all those who've helped put this reading together. It is my pleasure now to acknowledge Natomas Pacific Pathways Prep, again, a group from the drama department to read the preamble and to officially start our reading. Hopefully you're all clear on your instructions. It is like a Southwest flight. So in line, in consecutive order. If you have any questions, you can ask Daniel or my law clerk, Aditi. Aditi, where are you? Aditi Gottlieb is around to answer questions. So thank you all for being here. Natomas Pacific Pathways Prep Drama Department, if you could please come forward and start us with the preamble, and then we will follow you. Thank you.
The preamble to the United States Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty for ourselves and our posterity, do ordain and establish this Constitution for the United States of America.
Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he or she shall be chosen.
Representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. This infamous 3/5 clause in the Constitution was eliminated in 1868 by the 14th Amendment.
The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States and within every subsequent term of 10 years, in such manner as shall be by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative. And until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantation 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers, and shall have the sole power of impeachment.
Article 1, Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Immediately after, they shall be assembled in consequence of the first election. They shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. The 17th Amendment, adopted in 1915, changed this section of the Constitution to permit the direct election of U.S. senators.
No person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers and also a president pro tempore in the absence of the vice president or when he shall exercise the office of President of the United States.
The Senate shall have the sole power to try all impeachments. When sitting for the purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law.
Article 1, Section 4, the times, places, and manner of holding elections for senators, representatives, shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. The 20th Amendment, adopted in 1933, changed the date on which Congress convenes to January 3rd.
Article 1, Section 5. Each house shall be the judge of the elections, returns, and qualifications of its own members. And a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member.
Each house shall keep a journal of its proceedings and from time to time publish the same, excepting such parts as may in their judgment require secrecy, and the yeas and nays of the member of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting.
Article 1, Section 6. The senators and the representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses. And in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office.
Article 1, Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or consider with amendments as on other bills. Every bill which shall have passed the House of Representatives and Senate shall, before it become a law, be presented to the President of the United States. If he approve the law, he shall sign it, but if not, he shall return it. With his objections to the House, in which it shall have deliberated, we shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration, 2/3 of the House shall agree to pass the bill, it shall be sent together with objections to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of the House, it shall become law.
But in all such cases, the votes of both houses shall be determined by yeas and nays. The names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the president within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States. And before the same shall take effect, shall be approved by him, or being disapproved by him, shall repass by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill.
Article 1, Section 8. This following portion will be read in Ukrainian. Конгресові належить право встановлювати і стягувати податки, мита, збори, акцизні збори, сплачувати борги і дбати про спільну оборону і добробут Сполучених Штатів. Проте всі мита, збори та акцизні збори мають бути однаковими на всій території Сполучених Штатів. Брати позики ім'ям Сполучених Штатів. Регулювати торгівлю з іншими державами, штатами, а також з іноземними партнерами. встановлювати єдині правила натуралізації та єдині закони благоустрою на всій території Сполучених Штатів.
To regulate money, to coin money, regulate the value therefore and of foreign coin, and fix a standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. To establish post offices and post roads. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. To continue tribunals inferior to the Supreme Court.
This following portion will be read in Spanish. Para definir y castigar la piratería y los delitos graves cometidos en alta mar, así como las infracciones al derecho internacional. Para declarar la guerra, otorgar patentes de corso y represalia y establecer reglas en materia de capturas en mar y en tierra. Para reclutar y patrocinar ejércitos, pero ninguna asignación de fondos será este fin podrá abarcar un periodo mayor de 2 años, para disponer y mantener una marina de guerra, para establecer reglas para el gobierno y la reglamentación de las fuerzas de tierra y mar.
Provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress.
To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof.
The migration or importation of such persons as many of the states now existing shall think proper to admit, shall not be prohibited by Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. The use of the phrase such persons refers to enslaved people forcibly brought to America from Africa to labor in the building of the United States. When the Constitution was written in 1787, importation of slaves was permitted into the United States for 20 more years. Beginning January 1st, 1808, the importation of slaves and the transatlantic slave trade was outlawed by Congress, although slavery was not outlawed for 57 more years.
The provisions of the right of the habeas corpus shall not be suspended unless for any cases of illegality or invasion. The public safety may require it. No bill of the Assembly or its post facto law shall be passed. No type of fishing or other direct tax shall be led unless in the probation to census or immigration hearing before directed to be taken. The 16th Amendment adopted in the 1913 changed this clause of the Constitution to permit the federal impact tax.
No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another. Nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the treasury, but in consequence of the appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept any present, emolument, office, or title of any kind whatever, from any king, prince, or foreign state.
Article 1, Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin, a tender and payment of debts, pass any bills of attainder, ex post facto law, or laws impairing the obligation of contracts or grant any title of nobility.
No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspections laws. And the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States. And all such laws be subject to the revision and control of the Congress.
No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such eminent danger as will not admit of delay.
Article 2, Section 1. This will be read in Spanish. El Poder Ejecutivo se deposita en un presidente de los Estados Unidos. Desempeñará su cargo durante un término de 4 años y juntamente con el vicepresidente designado para el mismo periodo será elegido como sigue. Cada estado nombrará, del modo que su legislatura disponga, un número de electores igual al total de los senadores y representantes a que el estado tenga derecho en el Congreso, pero ningún senador, ni representante, ni persona que ocupe un empleo honorífico o remunerado de los Estados Unidos podrá ser designado como elector.
The electors shall meet in the respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of government of the United States, direct to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all certificates, and the votes shall then be counted.
This next section will be read in Spanish. Será presidente la persona que obtenga el mayor número de votos, si dicho número constituye mayoría frente al número total de electores designados. Y si más de una persona obtiene tal mayoría y recibe el mismo número de votos, entonces la Cámara de Representantes, por votación secreta, elegirá de inmediato a una de ellas como presidente. Y si ninguna persona obtiene mayoría, entonces la Cámara elegirá de la misma manera al presidente entre las 5 personas que aparecen por más votos en la lista.
But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest numbers of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by the ballot the vice president. The 12th Amendment, adopted in 1804, changed the way that the president and vice president are chosen.
The Congress may determine the time of the choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and then 14 years are resident within the United States.
In case of removal of the president from office or his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president. And the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly, until the disability be removed or president shall be elected. The 25th Amendment, adopted in 1967, altered the method of presidential succession described in this clause.
The president shall at times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall been elected, and he shall not receive within that period any other emoluments from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear
or affirm that I will faithfully execute the office of President of the United States and will do the best of my ability to preserve, protect, and defend the Constitution of the United States.
Article 2, Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. The President may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and the President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment.
He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. And he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law.
But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill all vacancies that may happen during the recess of the Senate by granting commissions, which shall expire at the end of their next session.
Article 2, Section 3. He shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in the case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States.
Article 2, Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors.
Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office.
Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority, to all cases affecting ambassadors or public ministers and counsel, to all cases of admiral and maritime jurisdiction, to controversies to which the United States be a party.
To controversies between two states or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. Footnote, the 11th Amendment adopted in 1795 changed this section of the Constitution to protect states against lawsuits in federal courts by citizens of other states or a foreign nation.
In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be in such place or places as Congress law have directed.
Article 3, Section 3. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted.
Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof.
Article 4, Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime.
No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim as a party to whom such service or labor may be given. The 13th Amendment abolishing slavery in 1865 eliminated the fugitive slave clause from Article 4 of the Constitution.
Article 4, Section 3. New states may be admitted by the Congress into the Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states, or parts of states, without the consent of the legislatures of the states concerned, as well as of the Congress.
The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state.
Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion. And on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence.
Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states.
Continue. Or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate.
Article 6, all debts contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding.
Senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States.
Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this constitution between the states so ratifying the same. Done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord, 1787, and of the independence of the United States of America, the 12th. In witness thereof, we have hitherto subscribed our names. George Washington, President and Deputy of Virginia.
New Hampshire, John Langdon, Nicholas Gilman. Massachusetts, Nathaniel Gorham, Rufus King. Connecticut, William Samuel Johnson, Roger Sherman. New York, Alexander Hamilton. New Jersey, William Livingston, David Brearley, William Patterson, Jonathan Dayton.
Pennsylvania, Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzsimmons, Gerald Ingersoll, James Wilson, Governor Morris. Delaware, George Reed, Gunning Bedford Jr., John Dickinson, Richard Bassett, Jacob Brew.
Maryland, James McHenry, Daniel of St. Thomas Jennifer, Daniel Carroll. Virginia, John Blair, James Madison Jr. North Carolina, William Blount, Richard Dobbs Spate, Hugh Williamson.
South Carolina, John Rutledge, Charles Coatsworth Pinckney, Charles Pinckney, Pierce Butler. Georgia, William Few, Abraham Baldwin, attest William Jackson, Secretary.
The preamble to the Bill of Rights. Congress of the United States begun and held at the City of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added and is extending the ground of public confidence in the government thus ensure beneficent ends of its institution.
Resolved by the Senate and the House of Representatives of the United States of America and Congress assembled 2/3 of both houses concurring that the following articles be proposed to the legislator of the several states as amendments to the Constitution of the United States. All or any which articles, when ratified by 3/4 of said legislator, to be valid to all intents and purposes as part of said Constitution.
Articles in addition to an amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislatures of the several states pursuant to the 5th article of the original Constitution. These amendments were ratified December 15, 1791, and form what is known as the Bill of Rights.
Amendment 1. Congress shall make no law respecting the establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances.
Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Amendment 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law.
Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
Amendment 6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no facts tried by a jury shall be otherwise re-examined in any court of the United States, then according to the rules of the common law.
Amendment 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Amendment 9, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Amendment 10, powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Article 3, Section 2 of the Constitution was modified by Amendment 11, passed by Congress on March 4th, 1794, and ratified on February 7th, 1795. Amendment 11, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state.
Amendment 12. Article 2 of the Constitution was superseded by the 12th Amendment. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. And they shall name in their ballots the person voted for as president, and in distinct ballots, the person voted for as vice president. And they shall make distinct lists of all persons voted for as president and of all persons voted for as vice president, and the number of votes for each, which lists they shall sign and certify and transmit, sealed to the seat of government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president if such number be a majority of the whole number of electors appointed. And if no person has such majority, then from the persons having the highest numbers, not exceeding 3, on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president.
But in choosing the president, the votes shall be taken by states. The representation from each state having 1 vote, a quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. This clause in Amendment 12 was superseded by Section 3 of the 20th Amendment in 1933.
The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person having a majority, then from the two highest numbers on the list. The Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that office of vice president of the United States. Amendment 13. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have the power to enforce this article by appropriate legislation.
Amendment 14, passed by Congress June 13th, 1866, ratified July 9th, 1868. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person in its jurisdiction the equal protection of the laws.
Article 1, Section 2 of the Constitution was modified by Section 2 of the 14th Amendment. Amendment 14, Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed.
Over the right to vote in any election for the choice of electors for president, the vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime. The basis of representation therein shall be reduced.
法律批准的合眾國公共務，包括因支付評定作練或反叛有功人員的年金和獎金而產生的債務，其效力不得有所懷疑。但無論合眾國或任何一州，都不得承擔或負償因援助對合眾國的作練或反叛而產生的任何的要求。 亦不得承擔或償付因喪失或解放任何皇帝而提出的任何賠償要求。所有這類債務、義務和要求都應被認為是非法效的。Thank you.
Amendment 15, the right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Congress shall have the power to enforce this article by appropriate legislation. Amendment 16. The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without appropriation among several states and without regard to any census or enumeration.
Amendment 17. Note Article 1, Section 3 of the Constitution was modified by the 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branches of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislator of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution.
Amendment 18. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution within 7 years from the date of this submission hereof to the states by the Congress. Amendment 19. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. Amendment 20. The terms of the president and the vice president shall end at noon on the 20th day of January, and the terms of senators and representatives at noon on the 3rd day of January of the years in which such terms would have ended if this article had not been ratified and the terms of their successor would begin.
Amendment 20, Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. No. Article 1, Section 4 of the Constitution was modified by Section 20 of the Section 2 of the 20th Amendment. Amendment 20, Section 3. No. A portion of the 12th Amendment was superseded by Section 3 of the Amendment 20. If at the time fixed for the beginning of the term of the president-elect shall have died, the vice president-elect shall become president. If a president shall not have been chosen before the time fixed for the beginning of his term, or if the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have qualified.
I will be reading the continuation in Spanish. Y con apego a la ley, el Congreso podrá tomar providencias en caso de que ni el presidente ni el vicepresidente electos reúnan los requisitos necesarios, declarando quién hará entonces las veces de presidente o el modo en el que se seleccionará a quien deba de actuar total, debiendo dicha persona desempeñarse en esa capacidad hasta que se designe un presidente o un vicepresidente que llene los requisitos. Sección 4. El Congreso podrá, de acuerdo a la ley, tomar providencias en caso de que muera cualquiera de las personas entre las cuales la Cámara de Representantes puede elegir un presidente, siempre que recaiga sobre ellos el derecho de hacer tal selección. Y en caso del fallecimiento de cualquiera de las personas entre las cuales el Senado puede elegir un vicepresidente, cuando el derecho de hacer tal selección recaiga sobre ellos.
Amendment 20, Section 5. Sections 1 and 2 shall take effect on the 15th day of October, following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. Amendment 21. Passed by Congress February 20th, 1933. Ratified December 5th, 1933. Second, the 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation to any state, territory, or possession of the United States for the delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited.
Amendment 21, Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the event hereof to the states by the Congress. Amendment 22. Passed by Congress March 21st, 1947, ratified February 27, 1951. Section 1. No person shall be elected to the office of the president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of president more than once.
But this article shall not apply to any person holding the office of president when this article was proposed by Congress, and shall not prevent any person who may be holding the office of president or acting as president during the term within which this article becomes operative from holding the office of president or acting as president during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by Congress.
Amendment 23, passed by Congress June 16, 1960, ratified March 29, 1961. Section 1. The district constituting the seat of government of the United States shall in such manner as Congress may direct the number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. Amendment 23, section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 24, passed by Congress August 27, 1962, ratified January 23, 1964. Section 1. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other tax. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment 25, passed by Congress July 6, 1965, ratified February 10, 1967. Note, Article 2, Section 1 of the Constitution is modified by the 25th Amendment. Section 1. In case of the removal of the president from office or of his death or resignation, the vice president shall become president. Section 2. Whenever there is a vacancy in the office of the vice president, the president shall nominate a vice president, shall take office on confirmation by a majority vote of both houses of Congress.
Section 3. Whenever the president transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the vice president as acting president.
Amendment 25, Section 4. Whenever the vice president and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the president pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the president is unable to discharge the powers and duties of his office, the vice president shall immediately assume the powers and duties of the office as acting president.
Thereafter, when the president transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the vice president and the majority of either the principal officers of the executive department or of such other body as Congress may by law provide transmit within 4 days to the president pro tempore of the Senate and the Speaker of the House of Representatives the written declaration that the president is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress, within 21 days after receipt of the latter written declaration, or if Congress is not in session, within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the president is unable to discharge the powers and duties of his office, the vice president shall continue to discharge the same as acting president. Otherwise, the president shall resume the powers and duties of his office.
Amendment 26, passed by Congress March 23, 1971, ratified July 1st, 1971. Note, Amendment 14, Section 2 of the Constitution was modified by Section 1 of the 26th Amendment. Amendment 26, Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation.
Amendment 27, originally proposed September 25th, 1789, ratified May 7th, 1992. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. This concludes our reading of the United States Constitution. On behalf of the Chief U.S. District Judge of the Eastern District of California, Kimberly J. Mueller, the Sacramento chapter of the Federal Bar Association, Operation Protect and Defend, the Ninth Circuit's Justice Anthony M. Kennedy Learning Center, and the Ninth Circuit Library's branch librarians, thank you very much for joining us today.